Tech startups is a trend now in the IT industry. Many IT professionals start their own companies to solve problems that the world is facing. In this video, we'll explain legal concepts that will help you start your tech company. Diligence. We are required to exercise diligence in every obligation that we do. Failure to do so may result in negligence, which may cause legal repercussions along the way. Here's a brief explanation of what negligence is.
In this video, we will introduce negligence. We'll say Perry is crossing the street, and just then, Dudley comes riding by on his bicycle into the intersection too fast, and there's an accident, and Perry gets hurt. In everyday conversation, we would say that Dudley was careless, and that his carelessness caused the accident. But if the parties go to court, we would say that this is a case about negligence. The defendant is being sued for being negligent.
Contracts. There will be a lot of transactions involving a contract when starting up a business, such as contract of sale, contract for your investors, and contract for your employees. There are 4 principles in making contracts. These are relativity, which tells you that there are no other parties involved except the agreeing party. Obligatoriness, which means that the law obliges you to carry on the obligation. Autonomy, which gives you the freedom to choose the terms and conditions except those that are unlawful and immoral. And mutuality, which tells you that it requires both of your consent to change any stipulations so that no party will take advantage of the other. Here are some things to watch out when making computer software and hardware contracts.
Now, there are a number of potential problems with computer contracts, and here are just 4. 1. The exclusion clause. See, this limits the liability of the supplier. For instance, your claim against the supplier may be limited to the price that you paid for the software. And if the software and services have brought your business to its knees, then you will find this to be a very small compensation. Who is going to use the software? Make sure that the name of the right company, employee, and the type of license is appropriate for the requirements of your business. In fact, there are 12 different types of license, and any changes in the license use will cost you money. For example, imagine if you get the name wrong and you buy the license for one company but you want to use it for another. What about if you have a license which allows you to use it at one address and you want to use it at a branch office too? Or you want to sell your business and transfer the software. 3. ESCO agreements. The source code should be held by a third party in case your supplier goes broke or just loses interest. Otherwise, you won't be able to make any changes to your software. 4. Termination. The contract will deal with what happens on termination if the matter goes badly wrong. For instance, if you don't hand over the money, then you can't use the system. Are the software suppliers sometimes quick to charge high fees for permission to use software in ways which was not in the contract? Well, yes, they are. In fact, in the software business, this is called stiffing and happens too often. Computer contracts need to be carefully negotiated. Be warned.
So these are some concepts that will help you build that startup. We discuss about diligence and the consequence of not doing it in contracts. Now organize your ideas and change the world one startup at a time.